Well, good afternoon. Welcome. My name is David Fott. I'm a professor of political science and director of the Great Works program here at UNLV. The Great Works program exists to encourage undergraduates to spend as much time as they can with the greatest minds who have ever lived. You can find a 9-page list of those minds on the program's website, Great Works program website. As of this fall, the program will offer a minor in Great Works as well as 2 options to earn a certificate. A minor for 18 credits and 2 options to earn a certificate, each of 12 credits. The information is in the handout that Mr. Navarrete passed around to you. I hope we may not have enough for everybody, but maybe you all have one now and can read about it. Either the minor or the certificate is a good way to certify to a prospective graduate school or employer that you have not wasted your time here at UNLV, that you've taken rigorous courses and studied serious books. In fact, the program also has a book club for students, which any student, undergraduate or graduate, may join at any time. We have 2 more meetings this semester, in fact, this Wednesday and next Wednesday. Now, there's going to be another change in the program as of this fall, and I'm happy to say that my colleague, Professor Mark Lutz, will take over as director of the program, actually beginning next month. He's going to get a head start. Raise your hand there. Not everyone may know you, Professor Lutz. Yes, he's been here since 2005 and worked with the Great Works program for a long time. He's well prepared to guide it as we begin the minor and the 2 options for the certificate, and I will be happy. I look forward to continuing to help students on the Great Works faculty committee of 12 persons. I think 2 other members of the committee here, Professor Margaret Harp and Professor John Hayes sitting in the very back. And I see one of our recipients here as well, Professor Nurses Kopalian, my colleague in political science, early recipient of the certificate. So you can go on to do good things by getting the certificate. Any of us would be happy to help give you more information about the program. Now, to today's lecture, I am most grateful that funding has come from the Jack Miller Center for Teaching America's Founding Principles and History. Our speaker today is Alan Kahan. He is professor of British civilization at the Université de Paris-Saclay. He is a senior member emeritus of the Institut Universitaire de France and previously was professor of history at Florida International University in Miami. He's written a number of books, including a translation of Tocqueville's The Old Regime and the Revolution, Mind versus Money, The War Between Intellectuals and Capitalism, Tocqueville, Democracy and Religion, and most recently, Freedom from Fear, An Incomplete History of Liberalism, which will be published this August by Princeton University Press. He lives in Paris and is a connoisseur of croissants. The title of his talk today is Tocqueville on American Lawyers and American Courts. So please join me in welcoming Professor Kahan. Let's see. Yes. All right.
I could ask for a show of hands if you'd rather I talk about Tocqueville or croissant, but I'd be afraid of what the response might be, so we will proceed in an entirely undemocratic fashion and consider Tocqueville. So first of all, thank you, David, for that introduction, and thank you to both you and to the Great Works program in general for inviting me here. I'm delighted to make my very first trip to Las Vegas, and without ever having visited a casino at that. So before I start talking about Tocqueville on American lawyers and American laws, I should make one thing perfectly clear. I am not a lawyer. And so I don't have any particular legal expertise as such. Tocqueville, of course, was a lawyer. He had a French law degree, which in his time required writing 2 theses, one in French and one in Latin. He practiced a very little bit. He was kind of an unpaid assistant prosecuting attorney for a couple of years until he got in hot water with all his friends and family because he accepted the July Revolution of 1830, all his family being legitimists and adherents of the old Bourbon dynasty. And in order to get away from all the disapproving looks of said family and friends, he got on a boat to America. And the result is, of course, democracy in America, one of those great works that get him on your 9-page list of great thinkers. Now, whenever I'm teaching democracy in America, one of the first things I do with the class is I ask them, what is this book about? Which, of course, is a trick question. I'm hoping that some unlucky student will raise her hand and say, well, it's about America, which will give me the opportunity to say, no, it's not. The book is titled Democracy in America. The subject of the book is democracy. America just happens to be, or not just happens to be, but is the place in which democracy is being performed. Why America? Because for Tocqueville, America was the society in which this thing, democracy, which was destined in his view to spread to the entire planet, was at its most advanced. So if you wanted to look at what democracy was going to become in Europe and elsewhere, you would start in America, and you would see what democracy would be like. Now, this required distinguishing between things that were characteristically democratic and things that were purely American, because, of course, America presented a mixture of the two. And a lot of democracy in America, the book, if you've chanced to read it, and if you haven't, of course, you should tomorrow. Big book, but get going. It says, this bit is characteristically American. This bit is characteristically democratic. And what I'm going to talk about today, Tocqueville on American lawyers and American laws, also shares that dual characteristic. American lawyers are like democratic lawyers everywhere for Tocqueville. American laws, however, and particularly the American Constitution, is unique to the United States. One more sort of preliminary bit of work to get out of the way here. This word democracy. We hear the word and we think it has something to do chiefly with free elections. Tocqueville occasionally uses the word that way, but most of the time that's not what it means. What it means, as he says in the opening paragraphs of the book, is a society based on, all the translations use this rather bad phrase, equality of conditions. The French is égalité des conditions. It's equally incomprehensible to today's French people as it is to today's Americans. What on earth do we mean by equality of conditions? What Tocqueville means by that is equality of social status. When you walk out of your front door in the morning, you presume that everybody you meet is your equal. That has not always been the case. For most of human history, you would presume that most of the people you met would be either your superiors or your inferiors. You would have very few equals, because society was an aristocratic society based on various more or less fixed forms of social class. Everybody knew it was that way and expected it to be that way. Democracy, this new thing, was based on the idea of equal social status. Whether you were rich or you were poor, you would be subject to the same laws, have the same rights, and be entitled to the same kind of dignity and respect. When Tocqueville talks about democratic society, that's what he means. No society, in his view, is perfectly democratic in this sense. He's well aware of slavery in the United States. He has a magnificent chapter on the three races talking about white people, Native Americans, and black people in the United States. Nevertheless, he says, taken as a whole, American society is more democratic than any other, and where it isn't democratic, it's peculiarly American as opposed to democratic. There are no Native Americans in Europe, for example. Okay, enough preliminary discussions here. So we're talking about lawyers, and we're talking about the Constitution. And let's start with the lawyers. Tocqueville notes something that was really rather quite striking from his perspective. In France, in Europe in general, lawyers were typically radicals. You looked at any revolution, any of the many French revolutions, any of the revolutionary movements in Germany, for that matter in 17th century England and so on, they were always led by lawyers. Lawyers were a kind of person that any good conservative was really suspicious of in Europe because they were likely to be revolutionaries. But in America, Tocqueville said, nobody has this attitude towards lawyers. Sorry, skip ahead of myself there. In America, he said, lawyers are conservatives. And he says, in fact, this is their natural position in democratic societies. They shouldn't be radicals. The only reason they are radicals in Europe is because in European societies, traditional aristocracies denied them their rightful influence on politics. But in fact, they are the natural aristocracy of democratic societies. So he writes, if I were asked where I see the aristocracy in America, I would answer without hesitation that I do not find it among the rich who share no common bond. The American aristocracy congregates in the courtroom, at the bar, or on the bench. Now, lawyers are a little bit different from real aristocrats, the kind you find in aristocratic societies. Those aristocrats are born. No one is born a lawyer, although I occasionally doubted this one thinking about my daughter in her childhood. You have to be made a lawyer. You have to become a lawyer. In that sense, it's quite democratic. We start with an equal status, but lawyers in democratic societies differentiate themselves from other people. And they do so, according to Tocqueville, in ways that are extremely beneficial to democratic societies, provided they're allowed to play their proper role in them. Unlike in Europe, where people tried to push them away from power, and as a result, they made revolutions to get themselves into power. So what's so great about lawyers? I mean, after all, Shakespeare said, first thing we do after the revolution, let's kill all the lawyers. And there are a lot of people who hold sentiments like that today. It's one of those few bits of radicalism common often to people on both the left and the right. Lots of people love to hate lawyers. So why does Tocqueville like them? Because they're different. That's what makes them an aristocratic element in a democratic society where people tend to all be more or less the same and have the same status, the same attitudes, and so on. Democratic societies, based on equality for Tocqueville, need to develop certain aristocratic elements if they are to preserve their freedom. Otherwise, we end up in a democratic tyranny, the famous tyranny of the majority that Tocqueville is known for, in which majority opinions, majority attitudes dominate everyone and everything, in which people are afraid to express different opinions and, even worse, think it's wrong to have different opinions. In such a society, you need to create aristocratic elements that are capable of standing out against the mass. There are lots of different ways to do about this. Tocqueville never has just one solution to any problem. He doesn't work like that. He always has at least a two-track mind. One aristocratic element in democratic society is associations. You individually can't stand out with your unpopular opinion on campus against everybody else. But form a group, form a club, form an association of like-minded people, and you have created a kind of elected aristocrat capable of telling the king to go screw off. That's what the duke used to be able to do. We don't have dukes anymore. Now we have associations. Or on another level, now we have local governments that can say this to the centralized national government. That's another aristocratic element in our societies. And yet a third one is, in fact, this class of lawyers who have been trained to think in a certain way and trained to be able to resist arbitrary power, the arbitrary exercise of authority. Lawyers want stability. They hate arbitrary decision-making. And if they're American lawyers, they are trained, or used to be trained, this may no longer be true, to put precedent, that is to put reality, above everything else. That is to say, they do not put theory first. They put the existing law first. And democratic people trust this aristocracy because we're used to the idea that a lawyer is someone you hire to advocate for you, which of course is what we want our politicians to do. So it's perfectly natural that so many of our politicians are lawyers. They are professional advocates doing what they're supposed to do for us and doing it because they're lawyers so often in a way that makes them somewhat independent of the crowd, fulfilling that aristocratic role and aristocratic function that democratic societies need to have someone to do. And since in America lawyers do get to run things, that was already true in Tocqueville's time. He came here in 1831. It's still true today in 2023 or whatever the current year is. And therefore, because they get to run things, they are essentially, according to Tocqueville, a conservative force. They are not going to be revolutionaries. They are not going to kick over the anthill, and they are going to enable democratic societies to remain stable in ways that otherwise they might find it difficult to do. Now, I've already implied a little bit of doubt about whether lawyers are currently fulfilling that function, and whether precedent and common law tradition is dominant in American law today. So let me suggest that today we have the sort of two leading theories of constitutional interpretation. Originalism on the right, that is the notion that to interpret the Constitution we have to go back to what the authors meant by whatever it was they wrote at the time they wrote it. And on the left, the theory of the Constitution as a living tree, which basically says, well, these words can more or less mean whatever we think they ought to mean in contemporary sensibility. Tocqueville, I think, would have hated both these theories equally. Neither of them is likely to be anything but revolutionary. They're going to make different kinds of revolutions, but they are both going to use the law, use the Constitution to make a revolution and deprive it and us as a society of the kind of stability that for Tocqueville was the whole point of the enterprise. Now, Tocqueville was also well aware that just because you were a lawyer did not mean even if you did not hold a particular theory, it did not mean that you were necessarily a force for freedom and upholder of stability and precedent and all these things. Later on, he experiences, later on being after the writing of Democracy in America, so he writes that in the 1835 and 1840. In 1848, France has a revolution, as it often does, becomes the Second Republic. Louis Napoleon is the president, makes a coup d'etat, becomes the Emperor Napoleon III, a dictator. And Tocqueville says, regarding this event, at every step of the way, Louis Napoleon had one of the best lawyers in France advising him why everything he did to destroy freedom in France was perfectly legal and in accord with the Constitution. He says you can always find a lawyer, if you're a despot, who will tell you what you're doing is really okay. So although Tocqueville admires lawyers as a class and their social function, he's well aware this does not make all lawyers good people, nor are all lawyers friends of freedom. And he's aware of this somewhat ambiguous role. So he writes, it must not be forgotten that if lawyers prize freedom much, they generally value legality still more. They are less afraid of tyranny than of arbitrary power, and provided the legislature undertakes of itself to deprive men of their independence, they are not dissatisfied. So, stability can't be our only consideration. It's merely a way of ensuring that the freedom we have works. It's a means rather than an end, but a very important means. Nevertheless, lawyers by themselves are not enough to preserve freedom. Still, it is something to have the protection from arbitrary power that lawyers give us. If you ever happen to be in a place where there really is no such protection, where you really are subject to arbitrary authority, I think you will find that you feel this really right away. I remember a few years ago I was invited to spend a week teaching in China. And when I came through immigration and had my fingerprints taken and my retina prints taken, and then was allowed to proceed, I thought, and now, if anybody wants to do anything for me from a position of authority, there is nothing that can be done about it. There are no laws here to protect me. And it's not a comfortable feeling, especially when you're going to talk about liberal political theory. But I can talk about Chinese freedom another occasion. That's also an interesting kind of subject. But in any event, because lawyers are the enemies of the arbitrary, they are an extremely useful element in a democratic society. And there are occasionally times when people say we have too many lawyers in American politics. Why don't we have people who know how to get things done? CEOs, for example. But CEOs have too much of a tendency to think that arbitrary authority is how they became as successful as they did. Lawyers know that they never get anywhere by trying to be arbitrary, and this has been drummed into them from the first day of their legal education. And this is why Tocqueville thinks they are, in fact, the people who we want to organize our societies. And in fact, they do, provided we don't try to keep them out, as was too often the case in Europe. Now, everything I've said about lawyers so far is essentially true for Tocqueville everywhere. Lawyers will be an aristocratic element in any and every democratic society. And you can see, in fact, in arbitrary societies, which can, in fact, be democratic in the Tocquevillian sense, that is, they presume equality, just everybody's equal under the despot. Lawyers are often playing a particular kind of role to limit despotic authority. This is even true in places like Russia and China in all kinds of ways. And so the role of lawyers is a universal for Tocqueville, insofar as democratic society is or is going to be a universal. It's not particularly American, even if the Americans, as is often the case for Tocqueville, have best known how to take advantage of this common democratic phenomena. Now, what is uniquely American for Tocqueville is the American Constitution, which has absolutely nothing like it in Europe. And Tocqueville is a great admirer of the US Constitution. He writes, "If ever America was capable of rising for a few moments to the high level of glory that the proud imagination of its inhabitants would like constantly to show us, it was at this supreme moment." Now, there's obviously a little bit of irony in here. The proud imagination of its inhabitants. One of the things like Tocqueville, like most visitors to the United States in the 1830s, 40s, 50s, notes is, the Americans, they think their country is the greatest thing since sliced bread. God forbid you criticize anything about the United States. They will immediately become extremely offended and give you a 3-hour lecture about why whatever it is you've criticized is actually the best thing in the entire universe. But he says, when it comes to the Constitution, they're right. This is the one thing in which America really is the best thing since sliced bread. And he goes on to say that the Constitutional Convention included, I quote, "the best minds and most noble characters that had ever appeared in the New World." So he thinks, Madison, Hamilton, and co. Were I used to use this phrase, but now nobody knows what it means. He thought they were the cat's pajamas. Raise your hand if you know what I'm talking about when I say the cat's pajamas. Most of you don't. In any case, he thought they were great. Okay, so it's not just the American Constitution, though, that's unique, according to Tocqueville. It's the entire role that law plays then, or played then, and really still plays now in American politics and American society. So he says, "In my eyes, the constitution of the judicial power forms the newest and most original portion of the entire political system of America." Now that's pretty striking, right? Tocqueville's coming to America in 1831. By 1831, essentially every adult white male has the vote. There is no place in Europe like that, or even close to like that. That's radically different. In America, there's no king. Outside of, in fact, Republic of San Marino and a few places like that, there's no place in Europe like that either. But that's not the most original thing about America for Tocqueville. It's the judicial power. Now, I have to be honest. Tocqueville, when he says something like this, he might very well say in some other place, it's a number of people who vote that's actually the most original portion. He likes to exaggerate it sometimes for effect. But it's still important and it's still striking that he puts so much importance, so much weight on how the Americans have organized their judicial system. And he says, "I do not think that until now any nation in the world has constituted the judicial power in the same way as the Americans." So, what's so unusual about this? Well, all kinds of things that to us are second nature. We think it's obvious that, of course, courts review the acts of the legislature, whether they're state legislatures or the national legislature, and say, well, this is unconstitutional, you can't do this, and so on and so forth. That kind of constitutional court essentially did not exist in Europe. In fact, there was no such thing as a court with the power to rule laws unconstitutional in France until the 1970s, and until its power was expanded really in the 1990s. The French did not have a constitutional court. In Britain, again, until the past couple of decades, there was no court empowered to say a law passed by Parliament was unconstitutional. What we take here as obvious and second nature is really not. And so Tocqueville comes here and is really struck by this kind of thing. And for Tocqueville, I mean, and it's still, as I want to go back to that, it's still really weird compared to the rest of the world. I mean, if I went around and asked the students among you, how many justices of the American Supreme Court can you name? You probably could all name at least one, and many of you could name several. And I have recently made this experiment in France. None of my students could name any of them. There are 9, just like in America. I can name one because there was a newspaper article about him 2 weeks ago. Typically, they are completely anonymous. Nobody knows who they are. Nobody even knows how they're appointed. The American Supreme Court, from near the beginning, from Marbury versus Madison anyway, has played a really unique role compared to other countries in the way it's been important to American politics and the way in which judicial decisions, from Marbury versus Madison to the Dred Scott decision, to Brown versus the Board of Education, to Roe v. Wade, and now Dobbs, have played in the United States. And for Tocqueville, that is significant too, because for Tocqueville, the more free a people is, the more power it gives to courts rather than to government officials making arbitrary decisions on their own without any kind of review by anyone else and without any check except possibly that of election. In Europe, Tocqueville points out, governments have always hated giving courts the power to supervise their actions. To have someone able to say, no, this regulation you just put forth doesn't actually fit with the law. Or there's a law saying you should put forward a regulation, you've never actually done it. Both of these are commonplace events in France. And until recently, there was no court that could do anything about it. Whereas in America, that's the first place anybody would think of going in a similar situation. Tocqueville is very much an opponent of what is sometimes called the administrative state. The idea that some bureaucrat can issue a rule and that's it. In America, that rule is subject to judicial review. Again, until very recently, in Europe and in some places in Europe still, such a thing did not exist. And for Tocqueville, that's an essential part of freedom, and again, a role that both lawyers and courts are necessary to play, and that only the Americans have known how to give this role to the courts. Now, that's not the only function of courts, of course, for Tocqueville. And one of the things that again strikes him about the American court system is the way the judicial power itself acts as a check on the majority and a protection for minorities. Now, when I use the word minorities here, you're probably not thinking of the people Tocqueville is thinking of. You may be thinking about women, you may be, even though they're majorities, you may be thinking about people of color, you may be thinking about people of various sexual orientations. The minority that Tocqueville is actually most concerned about and most afraid will get trampled in a democratic society is the wealthy. Because the real advantage of democratic government is not to guarantee the interests of all, as has sometimes been claimed, but only to protect those of the majority. In the United States, where the poor man governs, the rich have always to fear that he will abuse his power against them. That is to say, since there always have been, and perhaps always will be, more poor people than rich people, if the poor people are the majority and have the vote, how are you going to protect the rich from being oppressed by the poor? that's not a problem that probably keeps you up at night much. But it keeps rich people up at night. And for Tocqueville, the successful functioning of a free society is one in which nobody has to be kept up at night for fear of arbitrary authority. And it's the courts that can keep us, all of us, whether we're talking about the rich people or the black people or the LGBTQ plus community, from being afraid of arbitrary power. Because in different contexts, all of us can be and are members of minorities and in need of the protection of a court system and a judicial system against the power of the majority. So how does that power get exercised by courts? Well, through judging laws and regulations unconstitutional, which, as I have just said, is a relatively unusual thing in the history of the world, even to this day, and a unique thing in Tocqueville's times. Because we always think of any action of government as subject to review by the courts, in the United States, Tocqueville remarked this in 1831, and it's been true ever since, there is hardly any political question in the United States that sooner or later does not turn into a judicial question. And if you think about it, that's just true. And again, it's part of the America we all grow up in. And it's really weird. It is absolutely not true in any other place to my knowledge. Certainly it's not true in France where I live. Certainly it's not true in Britain where I have lived. And I don't believe it's true in any other country in Europe. And I don't believe it's true in any other country in the world. We have a judicial culture that is unique and that presents, according to Tocqueville, some unique advantages. But it's not just advantages. Although Tocqueville may think the American Constitution really is as good as the Americans think it is, he does not actually believe that it would be a really great idea to simply pick up American institutions and plunk them just anywhere else. They may or probably won't work. And furthermore, they have some potentially very serious drawbacks in the United States as well. And in particular now I'm talking about the American system of judicial review and the American tradition of, we'll call it, constitutional supremacy. And one of the reasons Tocqueville thinks this wouldn't be a good idea elsewhere is at the time he's writing in the 1830s, in those European countries which have written constitutions, when you have a written constitution, a constitution is supposed to be fundamental and basic, and in people's minds that means unchangeable. One of the things that's unusual about the American Constitution is, right there from the very beginning, you can amend it. It's not meant to be set in stone for all time. And therefore, if the Constitution is inadequate or if the courts get it wrong, there's a way for the people to do something about it. And he says, in fact, if you had an unchangeable Constitution, that would make the American judicial system disastrous, because it would mean that the judiciary and the Supreme Court in particular would have acquired a despotic power as the only people who could rule on constitutional questions, and those questions could never be altered because the Constitution could never be altered. Except, I may suggest, that is in fact exactly the situation we find ourselves in today. Some years ago, there was an interview on National Public Radio in which Justices Ginsburg and Scalia, both now late, were being interviewed together. As you may or may not know, they were also close personal friends, even though they almost never ended up on the same side of a court decision unless it happened to be 9-0. By the way, a surprising number of Supreme Court decisions actually are 9-0, but going on. And they were each asked to respond to the same question. And that question was, if you could change one thing about the American Constitution, what would you change? And despite her sainted status, I have to say that I think Scalia's answer here was both far more profound and far more interesting than Ginsburg's. Ginsburg's answer was fairly predictable. She said, I would put the Equal Rights Amendment in the Constitution. That would be the one thing I would change. What Scalia said was a statement of far more general import. He said, I would make the American Constitution easier to change. He said it ought to be hard, but it's much too hard now. And this, of course, would cover the Equal Rights Amendment, among other things. But particularly from Scalia's originalist perspective, that only works if you can change the Constitution if the original version wasn't very good or doesn't work anymore. And as you all ought to know, and many of you doubtless do, right now to change the American Constitution, it takes a 2/3 vote of both houses of Congress and ratification by 3/4 of the states. We don't do that very often. The last two actual amendments to the American Constitution, there was a trivial one passed in 1992 about congressional pay. It was actually left over from 1789 and finally got itself passed. But the last serious amendment to the Constitution was in 1971. That gave the vote to 18-year-olds. So 1971 to 1923, that's 51 years without a change of any real sort in the American Constitution. It hasn't always been like this. For example, in 1895, the Supreme Court ruled that a federal income tax was unconstitutional. The Income Tax Amendment was passed in 1909 and ratified in 1913. That's relatively quick work when America decided the Supreme Court had either gotten it wrong or, in any case, the Constitution needed to be changed. We can't do that anymore. I mean, by way of comparison, Germany's Constitution, today's Germany's Constitution, was written in 1949. It's been amended 62 times since 1949. I think Tocqueville might have thought 62 was a little bit excessive, and that's probably because the German Constitution, like most constitutions that aren't American, instead of being, 5 pages, is more like 100 pages, so it covers all this kind of stuff, and so is more subject to needing amendments. But making the American Constitution easier to amend, as Scalia suggested, would, I think, be a truly Tocquevillian solution to some of the issues that I've raised. And just for the fun of it, Scalia did not give any prescription for how he would make it easier. So I thought, since I was here, I might as well tell you how that ought to be done, in my view. So instead of 2/3 and 3/4, how about 60% vote of Congress and 60% of the states, and here I'll borrow something from European constitutional law, that provided those 30 states that vote to change the Constitution contain at least 65% of the American population. So you can't have a bunch of small, unrepresentative states being basically enough to change the Constitution. I think that would make it still certainly hard. Getting to 60 votes in the American Senate for anything is certainly not easy. But 75 votes of 75% of the states, or 66 votes in the Senate, that's pretty much verging on impossible now. I think that's something of what Scalia had in mind and would get us something towards what Tocqueville wanted, which is a very strong judicial power, but not a judicial despotism. In fact, there are two ways of making a constitutional judicial system more democratic. according to Tocqueville. And there's a bad way and a good way. The bad way for Tocqueville is what you do in Nevada. Elect your judges. Tocqueville, when he gets to America, is absolutely stunned to discover that in several American states, even in his time, judges are elected. He thinks this is both really novel and a really, really bad idea. He says about it, sooner or later, these innovations will have harmful results, and one day you will see that by diminishing the independence of the magistrates in this way, you have attacked not only the judicial power, but also the democratic republic itself. The only good way to make the system more democratic is to make the constitutions easier to change. Okay, let's go back to the courts and the constitutional system we actually have as Tocqueville saw them. I don't want to talk too long and take too much time away from questions. Tocqueville actually thought that the judges might be too reluctant to use their power, especially faced by the power of state governments. Kind of, in this case, one of those instances, I admit they exist, where Tocqueville's predictive powers were not very great. In Tocqueville's view, one of the reasons why you wanted a strong federal judiciary was to prevent the encroachment of state authority on federal authority. That's actually a big concern at the time of the American Constitution. We tend to think of it the other way around, federal government encroaching on state power. Madison was far more worried about state power encroaching on federal power. You'll see this in the Federalist Papers, which Tocqueville, in fact, had read very carefully himself. But he also recognized that the Constitution was sufficiently vague that there was a danger of federal judges going in the other direction. And he's particularly impressed with the potential power of the United States Supreme Court and the dangers this might pose. And he says, if in France the courts could disobey the laws on the grounds they found them unconstitutional, the constituent power would actually be in their hands, since they alone would have the right to interpret a constitution no one could change. They would therefore take the place of the nation and would dominate society, at least insofar as the inherent weakness of the judicial power would allow them to do so. And he looks at the American Supreme Court and he writes, when after examining the organization of the Supreme Court in detail, you come to consider all of the attributions that it has been given, you easily discover that never has a more immense judicial power been constituted among any people. And immense powers are immensely powerful and therefore immensely dangerous. But there are some limits, some built in and some more contingent to the power of the American Supreme Court. He writes, their power is immense, but it is a power of opinion. They are omnipotent as long as the people consent to obey the law. They can do nothing once the people scorn the law. And I want you to think back, for example, about Brown versus Board of Education and the whole process of desegregation in American history, and how the relationship of the power of the court to the power of opinion there was revealed to be a very delicate one, to say the least. And he says, now the power of opinion is the most difficult one to exercise because it's impossible to know its limits exactly. Often it is as dangerous to fall short as to go beyond these limits. The Supreme Court, in other words, cannot be too far behind or too far ahead of public opinion, otherwise it loses its power. And once lost, it's very hard to get it back. The last time the Supreme Court lost its power was the Dred Scott decision. And it only got it back after the American Civil War. Therefore, for Tocqueville, a good Supreme Court justice, they must also be statesmen. They must know how to discern the spirit of the times, to brave the obstacles that can be overcome, and to change direction when the current threatens to carry away with them the sovereignty of the Union and the obedience due its laws. And he writes, if imprudent or corrupt men ever came to compose the Supreme Court, the Confederation would have to fear anarchy or civil war. Once again, Tocqueville being precedent about the Dred Scott decision, and potentially, in many ways, about the situation that the United States faces today vis-a-vis the Supreme Court. So, as wonderful as the American Constitution and the American judicial system is, it's not a machine that will go of itself for all time. It's not something that puts American freedom and American political stability out of danger. Now, in a federal government, a powerful Supreme Court for Tocqueville is absolutely necessary. But it's never sufficient. As he says, as for me, I would never advise any people to leave to the courts the care of guaranteeing its liberty. I would be afraid that the courts would sacrifice it to the executive or to themselves. We need a constitution for the checks and balances it provides, but we need a check and balance on the Constitution and its interpreters, the Supreme Court. And that is ultimately the process of amendment, and that is a process that in today's America is clearly broken. And for Tocqueville, that is in fact a constitutional problem of the first order, and one which needs addressing. But that does not mean that it cannot be addressed. That's your job. So I'll end on that optimistic note. Thank you very much. So I'm happy to take questions in any form that they may come, or talk about croissants. Yes?
I'm just curious, Tocqueville's coming over to the United States in 1831 in the age of Jackson. Arguably, that's a period with quite a bit of political division along party lines, sort of a new era of that. And arguably today, it's as divided, the country's as divided along party lines as it's ever been. And so I wonder, when it comes to thinking about the role that judicial power plays, when it's so hard to amend the Constitution, I assume you'd agree, precisely because of division along party lines. Mm-hmm. How Tocqueville would have sort of seen that in the 1830s, or how the situation is different today. What I'm thinking in terms of like the necessity of that judicial power, precisely because you want to be careful about throwing control of the legislature to a party rather than to simply a temporary faction of individuals working together.
Well, I mean, absolutely. Party is the instrument of the majority in democratic governments. And he's precisely aware of this threat. He's very much aware of the Federalist Democratic split in the United States. He spends a lot of time talking mostly, but not entirely, to Federalists, and he's very much aware of the division in the United States. So that's why you need such a protection. And that's why, you know, when he's thinking of, isn't it a good thing that we have lawyers controlling much of government, he's thinking about Andrew Jackson, who's no lawyer, right? And who needs restraints in ways that other populist figures may need restraint. By, in fact, not just a judicial system, but a sort of legal mentality that tempers, at least to some degree, the way arbitrary power might otherwise be exercised. I mean, that's one part of your question. The other part of your question is, well, you know, so what's different between now and then? And for Tocqueville, certainly then, and we could have interesting discussions if it's true now or has ceased to be true, underneath all the many divisions of American society, even the slave-free division, there is a fundamental democratic unity that is both democratic in the sense of this egalitarian presupposition and has to do with a common American history and relationship to decentralization, association, and so on and so forth, that he thinks holds America together in ways that an American might not see simply because they take all that for granted. Tocqueville, as the foreign observer, the outsider, sees it and therefore emphasizes its importance. Yes?
To that point of him being like a foreign, seeing it from an outside perspective, do you think he was right to think like the oppressed should act, or the rich should actually be fear of being oppressed in America?
Well, he certainly spoke to a lot of rich people who feared being oppressed. And historically speaking, right, that has often been the case, that wealthy upper classes have seen things like, the progressive income tax as simply a form of robbery. Whether they should think this way or not is irrelevant. They simply fear this in terms of an oppression. It was universally the case in Europe that people felt that if you gave everybody the vote, well, the poor are the majority, so what are they going to do? They're going to vote to take the money of the rich and distribute it among themselves. Now, of course, they never actually do that. And one of the things Tocqueville does is explain why they don't do that. But he is pointing to the fact that it's dangerous for a society, not just for the masses to feel oppressed, but for the elites to feel oppressed. That either of those situations can lead you to tyranny. And we're very accustomed to thinking, oh, if you oppress the masses, you're going to have a revolution and tyranny, et cetera, et cetera. We're not accustomed to thinking the other way as well, which is why, in particular, I chose to emphasize it. And I also think that it's worth thinking about. That, to switch another one of my hobby horses, what liberalism is about is that none of these groups should be afraid of arbitrary authority. And this includes the rich along with all other minorities. Yeah?
So earlier in the presentation, you said that, well, with just like clarification on like democracy in America, is this he was looking in and he saw that for the most part we were all kind of like regular people, but then lawyers didn't really stand out and they assumed they're out from ground up. But they still do that today, but we're not, like, and back then you recognize that too, they weren't the same, nobody was really this, I forgot the word that you said, but
Equal status.
Yeah, people that, like, we aren't really, like true people of democracy, because we still have very large divides. So how would that play, like, in today, because today that divide is even bigger?
Your scale is very different from his. Tocqueville comes from a truly semi-aristocratic European society, and he knows very much that there are divisions between rich and poor in America. That's why he's worried about the rich being oppressed in certain ways. But he says, compared to a truly aristocratic society, which you Americans have no idea of, yeah, you really are equal. And you really do make assumptions about equality that European people don't. Look, some very simple sort of examples of this. One is in part the nature of the English language. Once upon a time, there was a distinction between, you and thou. We had an intimate, a familiar, and a formal you. Well, we don't anymore. We didn't even in Tocqueville's day. So everybody is you, and we're equal. Whereas vous and tu don't work that way in French, or usted and tu in Spanish, et cetera, et cetera, et cetera. Or again, when I get random phone calls trying to sell me things when I'm in France or when I'm in America. In America, they say, hi, Alan, how are you doing today? That's equality. In France, they say, I will translate, excuse me, Mr. Kahan, I'm sorry to disturb you. Let me introduce myself. I'm Mr. DuPont, and I would like to know if you want to buy windows, or whatever it is. that level of assumption of formality and difference and so on is still part of French culture, even though it is far more democratic now than 3 centuries. In America, you presume that these strangers can call you by your first name. I personally am appalled by this, but I've been living in France too long. So some people like it, but what can I do? Tastes differ. So yes, I mean there are differences, and Tocqueville. I mean, let me go to the immediate and obvious one. And too many people who've written about this have only read Democracy in America and have not read the old regime, so they don't know how Tocqueville actually finishes this conversation. So people have said, oh, Tocqueville was oblivious to these distinctions between white people and black people and American racism, which in fact is nonsense. I, in fact, would suggest that Tocqueville essentially predicts the entire existence of Jim Crow. What he says is, when you have, I mean, slavery is nothing new or unusual in the world. What's new and unusual about American slavery is that it's so racially oriented. And when you have a society in which you've had race-based slavery, he says, even if you abolished it, you're going to have mutual fear and hatred. He says the result is going to be a race war which the black people will lose. And people read this and say, well, what race war in America? And let me suggest that this is Reconstruction and Jim Crow. And he says, and that's where people sort of stop reading. In the old regime, he says, well, how does this actually end in a democratic world? And he's thinking there about France, but it's applicable just as much to America. He says, whenever you have a society based on hereditary caste, color being one, though not the only example, how do you know if that's being overcome and replaced by equality? He says there's only one way to know. He says in France, we still haven't done this despite the French Revolution. And certainly the Americans hadn't done this 50 years ago either. So this one thing, intermarriage. Not sex, not babies, but marriage. You want to know if racism is diminishing, if equality is rising? Look at rates of interracial marriage. What Tocqueville is talking about in France is look at marriages between aristocrats and non-aristocrats. In his time, damn few. So he knows that aristocracy hasn't been ended in France. He himself married a non-aristocratic woman. His family never accepted her, despite his best efforts. And he tells his nephew when his nephew's looking for a wife, look, I've had enough grief. Marry an aristocrat. And if you look at, interracial marriage, since it's legal in the United States, after Loving versus Virginia, there's a big burst that lasts about a year after Loving versus Virginia, and then it goes down to about near zero until the late 1990s, and has been rising rapidly ever since. And for Tocqueville, and this doesn't just apply to black people and white people, this applies to any other set of groups you might have in mind. This is, the story of the inevitable rise of equality and progress towards a democratic world. Are you there yet? No, in part because you keep discovering new forms of inequality, which democracy then immediately sets about hammering out. Men and women be another example, and I could talk a lot about Tocqueville on that, but I'll stop there. Yes?
You mentioned that the Supreme Court can lose its power if its views are distinct from those of the masses. Obviously, since the Supreme Court is unknown in its nature which way it's going to go in every single vote, is that a personality-based thing where we see representation on the Supreme Court, or is that a decisions-based thing where we look at their decisions and either agree or disagree with it?
Well, I think it's a matter of. Let me step back a second. It's not the Supreme Court's job is simply to follow public opinion. We won't need a Supreme Court, we could just have a polling system. Sometimes they need to be a little bit in advance from Tocqueville's point of view. Sometimes it might be better if they're behind. When we have, some hysteria over national security, it's great for the Supreme Court to be behind public opinion and say, well, actually, no, it would be nice if you didn't lock up all the Japanese in camps in World War II. That didn't happen, of course, but a behindhand Supreme Court would have been great. So it's not just a matter of public opinion polls, but it is a matter of statesmanship and understanding how far you can go in terms of opinion. This is not a matter of personalities. This is a matter, in part, obviously, of politics, but it's not simply politics, because lawyers look at politics differently, and Supreme Court justices are lawyers above all else. It's also, at least in the ideal for Tocqueville, a matter of people who are taking precedent and the actual social situation very seriously, and not running to make the law conform to their particular theory of originalism, constitutional living tree, any of those kinds of things. So all those things are at work. I think that answers your question. Other questions? Yes?
Did Tocqueville mention anything about lifetime appointments?
About what, sorry?
Lifetime appointments.
What he cares about is what he calls the unremovability of judges, right? You shouldn't be able to not reelect them. It shouldn't be easy to impeach them. Yes, if they take bribes or something like this, you should be able to impeach them. He doesn't, excuse me, to the best of my knowledge, ever talk about lifetime, except in this context. This is one way to make sure that they are not simply political appointees or elected appointees. Lifetime is such, remember, damn few people made it to 80 in his day. And if so, in any kind of shape to be on a court. So this is one thing he's really not thinking of in our sense. Yeah.
I think in the Constitution, so Article 3, which essentially lays out the whole, process of the system of courts, was it Article 42? Anyway, the point is, the whole time the whole point of illustrating that the courts were, the judges, the Supreme Courts were not, justices were not going to be subject to voting or anything like that. That's basically so they weren't subject to social pressures. So essentially, they didn't have to win their seat on the Supreme Court. They could just, rule as they saw fit and not be held to standards or to the public opinion, as I think we were discussing earlier. What would Tocqueville think of that?
Well, he loves the Constitution, including that clause.
Okay.
Right? I suppose, let's take the case of, I think it's Felix Frankfurter I have in mind, right? So he's a New Deal aide to Roosevelt, and he's bitterly, the Supreme Court keeps ruling unconstitutional all kinds of New Deal legislation, and he loudly says how horrible the Supreme Court is. Then he gets appointed to the Supreme Court, and all of a sudden, he's voting to uphold all kinds of very conservative legislation. And it turns out he holds an interesting but entirely consistent theory. He says the Supreme Court should almost never rule anything unconstitutional that the elected government does, whether it's on the left or on the right, unless it's egregious, don't do a thing as the court. Now, I think he's one of, from a Tocquevillian perspective, that's a disastrous judge, right? He's not understanding the role of the court as the protector of minorities against majority tyranny. So, yes, you want judicial independence, but the judicial independence needs to be understood as independent of social pressure and not simply a rubber stamp for politics. And in Frankfurter's case, he would rubber stamp anybody's politics, just about. Now, that's unusual, but it's definitely a bad thing. Yes?
As we see democracy start to decline all over the world and in America as well, but the Constitution still has the status for Americans as, we read Fetter's papers right now, but as something almost religious, we really uphold the Constitution as something so wonderful. Do you think that making it easier would yield any type of change if there's because we still think it's so good, even yeah.
That's a really good question. But let me start with the first thing that you said, democracy is in decline. From Tocqueville's point of view, democracy is not in decline at all. Freedom may be in decline. That's a different thing. You can have democratic despotism, you can have democratic freedom. Democratic despotism is going up, democratic freedom is going down, but democracy, this notion that we all have equal status, that's not being challenged by any new aristocracy anywhere. But, I mean, what you are saying is that Tocqueville is a Protestant and there's a Catholic objection, to put it in a certain way, right? If you mess with dogma, if you mess with the faith, if you make it too easy to change the Constitution, you know, if you let priests marry, whatever, aren't you going to shake the American civil religion of faith in the Constitution? That's a really important point to make. Tocqueville does not consider that point. I think what he has in mind, though, is that's why it has to be hard. But it's got to be possible. After all, you know, even the church needed Vatican II. You need to be able to reform your civil religion. And so you have, you know, Brown versus Board of Education, and desegregation, and Loving versus Virginia, and interracial marriage, and so on. That needs to be able to happen, and he thinks if you do it judiciously, in fact, you must do it to maintain the faith. If you don't do it at all, you're going to lose the faith. And if you do too much of it, you're going to destroy the faith too. So you've got to find that very happy and difficult to find median, which he thinks at his time the Americans have been pretty good at finding. But, you know, we're a little different further on now, and perhaps we're having a little harder time finding it. But yeah, I think that point that you're making about don't you shake the religion by changing the articles of faith, yeah, that's a really important point, and that's one of the real reasons why it needs to be hard to change the Constitution. Yes?
Does Tocqueville not consider that question about the need for veneration, as Madison said, of the Constitution, because he thinks that mores, manners, customs, are more important than the laws?
Oh, it depends which chapter you read, right? Tocqueville says in one place mores are more important than laws, in another place that laws are more important than mores, or at least that they make mores, et cetera, et cetera. He's not really that concerned, right? Is he being contradictory? Well, consistency is the hobgoblin of little minds. Look, the way I describe this is, you know, you look at the rock one way and, well, there seems to be a lot of gold in it. And you turn over the rock and it seems to be more copper colored. Which was the rock? Gold or copper? Well, it's both. It depends on what facet you're looking at for what purpose. So sometimes it's the mores that do all the work. Sometimes it's the laws. Sometimes it's the institutions or the political system, depending. So, I mean, to put this in terms of the American judicial system, sometimes that judicial system is the be-all and end-all, but, you know, not by itself. Just as lawyers are not the only aristocratic element you need in a democratic society, you need associations, you need decentralized government, you need lots of these things. And asking which is more important, this is going to be, you know, a matter of circumstances for Tocqueville. It's not going to be a one-size-fits-all law of gravity kind of thing. I think there was another hand that I skipped at some point. No? Oh, yes?
So most constitutional law is decided in either it's decided either original intent or like the letter of the law. But now it's more decided on precedent. Do you think that's a danger, this thing to democracy?
Well, Tocqueville likes law based on precedent, right? He likes a common law system because the others, he thinks, A, can provide much more instability, and because they tend to give too much power to somebody's theories, which can often ride roughshod over the freedoms of others. So this is why he thinks, you know, a common law-based system is superior to a Roman law kind of system, which is really interesting because Tocqueville is trained as a Roman-type lawyer, right? French law is based on Roman law. It's not based on precedent. It's based on a certain kind of theoretical construction of the text. And he thinks the Anglo-Saxon common law system is far superior. He says the Roman law is the ally of despots everywhere. And that if you look at the history of enlightened absolutism in the 18th century, it's a matter of destroying common law and replacing it with Roman law because it gives more power to the king. Yeah?
You can correct me if I'm wrong, but I believe that Tocqueville's time in France, when it came to decision making.
So can you say that again? I didn't quite hear that.
Sorry. You can correct me if I'm wrong, but I believe in Tocqueville's day in France, when it came to decision making, they were very kind of impartial when it came to their own religious views and how that played out. Do you think you would feel that today in your ceremony?
I mean, religion, well, no, they certainly were not impartial in Tocqueville's France about religious views, right? France, until really quite recently, was a sort of permanent civil law between, Catholics and secularists. And this very definitely affected people's politics in all kinds of ways. Now, but Tocqueville, and I wrote a book about this, Tocqueville, Democracy and Religion. Tocqueville has a lot to say about the proper role of religion in democratic societies. And although he's well aware of the problems that certain kinds of religious fanaticism can pose, he also thinks that widespread and sincere religious faith is incredibly important in democratic societies, precisely because it gives people the moral strength to withstand majority tyranny, right? Because, God's a majority all by God's self. And it's the only sovereignty that can really stand up to the people. And when we all have lots of different notions of this divine sovereignty, because we have lots of different religions, this helps a lot. It helps in 96 other ways, which I don't have the time to go into. But he would not see, religion as a problem, as such. In fact, he sees it as, at least the right kind of religion, as the solution. But he sees the wrong kind of religion as very dangerous. But what he means by the wrong kind of religion is going to take me way too much time to talk about, so I'm sorry, I'm just going to stop. Read the book, what can I say? Or better yet, read Tocqueville, but you can read me instead if you want.
Well, thank you for the clarification.
Okay? One more? Yeah.
American croissants versus French croissants?
There is no such thing as an American croissant. That's easy.
That's the easiest question I think we asked.
Right.
And on that easy note, we'll let you go with glad that you all could come, and may I say a belated thank you to someone who left, our graduate assistant, Kevin Navarrete, another recipient of our Great Work Certificate, who helped arrange this presentation. Special thanks to Professor Kahan.
Thank you.
Coming so
Thank you.
far.